Are we okay to get started? Great. Good afternoon, everyone. Thank you all for joining us. And I'm sorry. I thought you were. Thank you all for joining us today for Our Rights, Our Court, which is a review of the Supreme Court's 2022 term. I am Erin Martin. We unfortunately do not have enough tints to put everyone's name up in front of us, but I will introduce our panelists and make sure that I reiterate our names while we're up here, so that way you all remember. My name is Erin Martin. I'm the Director of Nominations and Cross-Cutting Policies at the National Women's Law Center, which is headquartered in Washington, D.C. For those who aren't familiar with the National Women's Law Center, it's been at the forefront of legal and advocacy fights for women and girls and gender justice for over 50 years. And I lead our federal and executive nominations, judiciary, and democracy work to push for a fair and impartial judiciary committed to equal justice for all that understands the impact of the courts on the ability of women, girls, people of color, LGBTQ plus people to live our lives free from discrimination. I'm happy to be joined by, I'll start with my current colleague, Bayla Spideman, who is in the middle here. Bayla serves as our Director of Educational Equity and is Senior Counsel in the Education and Workplace Justice team at the National Women's Law Center. In her role, she advocates for policies that keep girls of color from being pushed out of school, for the rights of pregnant and parenting students, and for equal access to education for women and girls. I'm also happy to be joined to my immediate left by Brielle Green, who serves as Senior Legislative Counsel at the premier public interest law firm Earth Justice. Brielle uses her expertise to fight for access to justice and regulatory reform issues. Additionally, Brielle covers judicial nominations and judicial reform for Earth Justice. Brielle has spent the last 9 years of her career advocating for solutions that improve racial equity and give a voice to frontline communities. And last but not least, on the end, I'm happy to be joined by my former colleague from my time at the Lawyers Committee, Jennifer Wakchukwu, who is counsel at the Voting Rights Project at the Lawyers Committee for Civil Rights Under Law. She uses a community-based approach to litigate voting rights and civil hate incident cases in both state and federal court, as well as engage in other forms of advocacy around these issues. So, we can kind of jump right in and get started. So 2 weeks ago, the Supreme Court wrapped up its 2022 term with some demoralizing decisions on our rights, to say the least. And while the Supreme Court has historically always been comprised of more justices appointed by conservative presidents, the current court features an extremist supermajority against our rights that's been neglecting the rule of law and stare decisis in recent years. This, along with the recent revelations on ethics issues with the justices, which we won't get into today, has created a legitimacy crisis at the court. Last term, for the first time ever, we saw the Supreme Court take away a constitutional right as we lost the constitutional right to abortion and bodily autonomy in the Dobbs decision. In the years since, we've seen and heard the heartbreaking stories of people being forced to carry pregnancies, some unviable to term, at times with their own lives at risk. The increased travel burden on those seeking abortion care, the closure of abortion clinics across the South, and it's become clearer to more and more people the broad impact the courts have on our ability to make decisions about our lives and thrive in society. Just this past April, we saw the court temporarily block yet another attack on access to abortion, this time through a challenge to the Food and Drug Administration's ability to regulate medication abortion. In that case, a Trump-appointed lower court judge injected his own personal views on the safety of the medication over that of the experts at the FDA. And while we're happy the abortion pill wasn't abruptly taken off the market in April as the lower court judge sought to do so, that case is likely to wind up before the Supreme Court again in the months ahead as it works its way up through the lower courts. But this attack on the FDA and federal agencies, unfortunately, is not new. We've seen a barrage of attacks by the court on the ability of federal agencies with expertise to regulate safety measures for the public. I'm going to start off with Brielle. Can you walk us through the Sackett decision and how it relates to attacks on the regulatory state more broadly?
Sure. So Sackett v. EPA is a case that was essentially about the jurisdiction of the Clean Water Act, and more specifically about a permitting program which controls whether people can fill in wetlands to be able to build on them, essentially. And the Clean Water Act, in case you didn't know, is the principal protection against harmful pollution and development to our water, the water that we drink, swim in, fish in, that we literally use to survive and that ecosystems use to survive. So even though this case was central to the Clean Water Act, the implications certainly reach into all agency authority, since the specific agency that this case was focused on is the Environmental Protection Agency. since they are, in control of making sure that the Clean Water Act is enforced. But the implications go beyond that with all of the ways in which the majority opinion seeks to really target the way an agency is able to interpret statutes and therefore enforce the law. So I think that while we can restrict the opinion to the environmental context or the water context, I think that it's a clear designation that the court is hostile to the administrative state and to regulations generally. There are multiple tones within the majority opinion that ultimately takes the opinion of a minority opinion from Scalia in the Rapinos v. United States opinion to restrict protections of wetlands. By doing so, they also hearken to the way in which the administrative state tends to control or minimize private party interests. And really what we're talking about in this case would be like polluting industry. So there are multiple quotes throughout the majority opinion that essentially seem to be pointing to a bright line sort of rule that makes it so that Congress must be exceedingly clear with the language that they use in statutes in order for a government entity or an agency in this case to regulate. And so that is really a direct attack to the ability of all of our federal agencies to enforce the federal laws that protect us where states are unable to, such is the case with water, which is substantially something that needs to be protected at the federal level, and Congress saw that, which is why they amended the Clean Water Act so many times, because it was very clear that the states either didn't have the capacity or the willpower or desire to really rein in polluting industry.
Thank you. So after Sackett, are there any silver linings for wetlands? Where do we go from here? How are we going to move forward?
Well, that's an interesting question. So I think, for one thing, it's worth noting that this case, while yes, it focused on specifically wetlands on the Sackett's property, the implications are really vast. Essentially, more than half of this country's wetlands are now at risk for being filled in and completely just taken away, destroyed. So I don't want to understate that. This is a thin silver lining. But the case focuses on one specific permitting program. That is the permitting program that controls whether you can fill in wetlands. There aren't implications that it touches the other successful permitting programs around the control of discharge or chemicals into wetlands and waters that are protected under the Clean Water Act, and there's precedent that seems to state that these two things are very separate. And so while, yes, this means developers can fill in more wetlands without going through the procedures required to get a permit, and are more likely to do so because it's going to be cheaper for them to do so, they can't pollute those wetlands. So it's kind of, because ultimately, would you rather the wetland be completely destroyed and taken away or polluted? Neither is great, but the other permitting program still stands. So I would say that's the thin silver lining.
And how is this impacting us? Like, how do wetlands benefit us? So how are communities of color, and more specifically Black communities, going to be impacted by wetlands no longer being protected?
So I don't want to all lives matter wetlands, but it will impact all of us, and some of us more readily than others. With that being said, there is clear data that shows that Black and brown communities live closer to floodplain lines, sewage, outage, those sorts of spaces that are already vulnerable to extreme flooding and or drought. Think communities that are all along the Gulf, all in the South. Those states do not have the best water protections there already, and now we're going to have to rely on the states to protect these wetlands, since under this new decision, only those wetlands that have a continuous surface connection, which is a little unclear what that might mean, only those will be protected. So ultimately, when you take away a wetland, you're heightening the ability for something to become flooded, for there to be more extreme droughts. We live in a reality in which climate change is real and is intensifying. So that means more extreme weather events, and those communities that already live close to those wetlands, some of which have already been destroyed and have seen the devastation of that, that's going to continue. Culture being taken away, homes being taken away, and ultimately more climate refugees.
Wow. And as I mentioned before, since the overturning of Roe, we have seen a barrage of threats to access abortion, and they've primarily been across the South and in the Midwest. You were just alluding to the wetland issues along the Gulf Coast. How are those restrictions that we're seeing popping up in the South connecting to the threats that we're seeing for environmental justice as well?
So I think it's worth noting that, in the last term when the Supreme Court overturned Roe v. Wade, they also minimized EPA's ability to address climate change in the West Virginia v. EPA case. And when you think about it, all of those areas of the country that you just mentioned are those areas that are vulnerable to climate disaster. So the same communities, women, girls, trans, non-binary, non-conforming individuals that will no longer have the ability to control what is happening to their body are also living in those same areas that are vulnerable to climate disasters. And when that happens, that means people will have less access to safe shelter, to safe housing, putting them more at risk to violence, which could ultimately lead to unwanted pregnancies. And then you add in the other layer of when you live someplace that has poor environmental regulation and control, and you live essentially like what's considered a frontline community in a corridor that has heavy industry, you are already more susceptible to health risk and vulnerability in your pregnancy, low birth rates, stillbirths, miscarriages, et cetera. So you have the implications of pollution to a pregnancy, whether you want it or not want it, and then in addition, more chance of there being violence brought against you. And there are studies that show that as more extreme weather events happen, that there's an increase of domestic violence and violence against those same vulnerable communities. So the intersectionality is unseverable.
Wow, thank you. So as I mentioned at the top, we've seen the Roberts Court completely be okay with overturning the rule of law and prior precedent. I'm going to turn it over to my colleague Bayless, who I know you worked on a brief in the Students for Fair Admission case v. Harvard and the UNC case as well. And I know my colleague Jennifer, the Lawyers Committee, actually argued the case as well. But I will turn it over to Bayless. So can you walk us through the SFFA cases on race-conscious admissions and tell us a little bit about what they mean?
Yes, absolutely. So just to give an overall synopsis of the case, it was brought by Students for Fair Admissions, and most of us in the room probably already know this, but in case you don't, it's not a student-led organization. It was founded by a conservative legal strategist, Edward Blum. He's the person also behind Fisher versus UT Austin, and he was also behind the Shelby County versus Holder case as well. So he's been really busy these past few years. So Students for Fair Admissions brought the case against Harvard and UNC, and just thinking about this strategically, Harvard is the oldest private university in the country, and UNC is the oldest public university in the country. Apparently that's debatable, but yes, UNC is the oldest public university in the country.
It's not debatable as a UNC alum. But continue.
Yes, absolutely. And so ultimately, their complaint stated that Harvard was violating the 14th Amendment and the Title VI 14th Amendment Equal Protection Clause and Title VI because they were intentionally discriminating against Asian American students in the applications process. And the complaint against UNC alleged that there was a racially neutral alternative that they could have implemented to have a racially diverse class that they didn't, and that violated the 14th Amendment as well. So just to give a little bit of a case background on how we got to where we are, for those who may not know, ultimately Plessy versus Ferguson was a decision in 1896 that established that separate but equal is constitutional as a legal doctrine. That was a case brought against the Louisiana Separate Rail Act that separated rail cars for black and white passengers. In 1954, we see the Brown versus Board of Education case overturn the Plessy decision, saying that separate is inherently unequal and that it violates race-based separation of public schools, public accommodations, is a violation of the 14th Amendment. Then in 2003, we see the Greta versus Bollinger case, which the Supreme Court there established that having a racially diverse student body is a compelling governmental interest, and in order to ensure that your student body is diverse, you can consider race as one factor in a holistic admissions process, and that admissions process must pass strict scrutiny review, meaning that your process must be narrowly tailored to meet a compelling governmental interest. So then we see the Fisher versus UT Austin case, which pops up in 2016. That was decided, and the court determined that their admissions process was aligned with the Greta decision, that it did not violate the 14th Amendment. So Edward Blum comes back with another case, and in Fisher versus UT Austin, the applicant the main plaintiff in that case was a young white student, a white girl named Abigail. And here we see Edward Blum then makes the argument on behalf of Asian American students for the Harvard case specifically. And the court did say, and this is a very interesting opinion because the court did not explicitly overrule Greta versus Bollinger in this case. What they did was, they said, based upon what we determined in Greta versus Bollinger, UNC and Harvard did not meet that standard of strict scrutiny review in terms of their admissions processes. So they said both schools violated the 14th Amendment Equal Protection Clause, and that there was no goal, essentially, no end goal put in place, and that is part of what violated that strict scrutiny review. Ultimately, again, Greta is not overturned officially, but it makes it very, very difficult for universities to consider race in their admissions processes. I mean, there is a carve-out in the decision that says universities can consider race as like the experiences that applicants have with race at overcoming barriers in their admissions essays, but ultimately, very gutted Greta versus Bollinger without explicitly doing so.
And what does this case mean for other protected characteristics that are used during the admissions process?
Yeah, so I would say when it comes to higher education admissions, we're doing our best right now to read this specifically as applying to Harvard and UNC's process and program, and we're trying not to consider it as expanded to other protected class categories. However, it is important to just know, I mean, this is a part of a broader landscape right now in attacking diversity, equity, and inclusion programs, and we see it in the anti-CRT movement and the censorship of education and books and in the classroom. So it's part of a broader movement, and also just to note for the audience, outside of higher education admissions, we are seeing a lot of cases come up from men's rights groups using Title IX to allege that, like, diversity programs to include more women in sciences, that is discriminatory against them because they're a man and they're not able to join the program. So we're seeing a lot of that pop up, so I would just say that everyone should remain vigilant about some of the other protected class categories, but right now we're not reading it as including the other ones.
Thank you. And how can universities still attract a racially diverse student body? A lot of the reporting that has come out from this case has been the end of affirmative action, that colleges are not going to see any Black students or Hispanic students anymore, and it kind of seems like there's been a bit of going beyond what I think a lot of the advocates would say is this decision is only applicable to the admissions program specifically at Harvard and at UNC, and doesn't speak to admissions programs which vary across the country at different universities. Mm-hmm. So what can universities do to still attract a racially diverse student body, and what can advocates also do to help not dissuade and discourage students? Because I think it can be very discouraging for young Black students and young Hispanic students as well if they're seeing all of these news reports saying they're not going to college anymore.
Yeah, definitely. If you're on the front lines on this issue, let's not give them any more than they've already taken. So, yes, they said Harvard's program and UNC's program violates the 14th Amendment, but institutions of higher education can still implement diverse programs to recruit. The court did not say that a diverse student body was not a compelling governmental interest, and so therefore universities should still continue with their programs. There are a number of things universities can do if they're concerned about considering race in terms of their application process, and that could include removing standardized testing requirements, which a number of universities have already done, having some stronger recruitment efforts in like Title IX school districts or school districts that serve predominantly Black and brown students, making sure that there's more financial support so that once you get those students in the school, that they can actually stay and complete their program, and just making sure that there's greater access for first-generation students as a priority over any legacy admissions that you may have. And I do want to quickly lift up, the NAACP has a diversity no matter what pledge for institutions of higher education. That is fantastic if you guys want to take a look at it. That was released on July 3rd, but it just sets forth some priorities that universities should have at the moment to ensure that they have a diverse student body, which would include like recruiting diverse faculty and staff that can serve on committees and make sure that students have mentors while they're there, and again, ending legacy programs and removing the racially biased standardized testing assessment. So, yeah.
I saw there was a recent lawsuit that I think an affiliate of the Lawyers Committee actually filed challenging the legacy admissions at Harvard, I believe, as well. So I think what you're raising in terms of also what's coming up with the pledge in terms of saying that universities should try to attract racially diverse professors and to serve on committees, I'm thinking about what impact this decision might have on race-conscious policies outside of higher education. Are advocates planning for that? I know this decision just was handed down 2 weeks ago, so I know it's still a bit fresh, but also just wondering if advocates have anything that they're planning in that space or anything that you could share with us today.
Yes, so we are, again, reasserting, even especially in the workplace environment, we're telling businesses to not get rid of your diversity initiatives because the decision did not explicitly apply to workplaces, and again, let's not give them any more than they've already taken. If they want that, we'll let them sue for that, but you know, just making sure that you continue the programs that you currently have in workplace environments. I would also say that, I do think that we could see a decline in diverse representation in some, like, medical programs and law schools, and however, noting that historically black colleges and universities, tribal colleges and universities, and minority-serving institutions such as Hispanic-serving institutions do a really great job at producing disproportionately teachers of color and producing lawyers, judges, doctors. So really getting behind those organizations right now and making sure that they have the funding that they need to continue to do the great job that they're doing in terms of producing black professionals. Ultimately, I do think that it will be important to just generally stay on top of these issues because we are seeing some, lawsuits pop up around, challenging workplace initiatives. We did see, I'm not going to name the state because I'm not going to give them more than they deserve, but a couple of conservative policymakers popped up after the decision and said, yeah, now we're getting rid of the diversity scholarships, and that is not what the decision said. So reading far more into it than it should be, and we should continue to push back against those people.
Thank you. So now turning to a couple of surprise decisions where the court did not overturn what a lot of us were expecting in the voting rights arena. We actually saw the Supreme Court follow its own precedent, which was quote-unquote surprise, in the Milligan and the Moore v. Harper cases. Jennifer, can you walk us through what was at stake in Milligan with Section 2 of the Voting Rights Act? And this is, again, where we're seeing the idea of a race-neutral approach being proffered. The race-neutral approach was what was proffered in the race-conscious admissions cases. They basically said that the Equal Protection Clause was race-neutral, even though we know that the purpose of the 14th Amendment was to give citizenship to the formerly enslaved Black Americans. So, but Jennifer?
Sure. Candidly, a lot was at stake in the Milligan case because ultimately what this case raised was a question of what is the proper standard of review for a claim under Section 2 of the Voting Rights Act. So the Section 2 of the Voting Rights Act specifically prohibits discrimination in the methods of elections that are used. And it also says that these processes, procedures, standards, et cetera, must be equally open such that minority voters are able to elect their candidates of choice. Now, the Supreme Court held in a case, Thornburg versus Jingles, which is a case that's almost 40 years old at this point, that established what the proper standard of review is for a claim under Section 2 of the Voting Rights Act, acknowledging what the statute itself says about race in order to actually review the statute, review whatever procedure has been put in place, and then determine whether there's been a violation. This case, and the reason why we're cautiously optimistic going into it, but still very surprised by the outcome, is because the state legislative defendants in Alabama had raised a completely different standard of review that suggested that there should be a more race-neutral benchmark to assess whether there's been a violation of the Voting Rights Act. And the court was very clear in saying, one, that the precedent established in Thornburg versus Jingles, which has since been used in its progeny for the last 37 plus years, is the proper standard of review. So it reaffirms the standard that we all have been using for the last almost 40 years and which is being used currently in cases all across the country. And then the court also talks about race consciousness versus race predominance, and it does say that there is a distinction between those two concepts, and it also specifically notes that inherent in Section 2 of the Voting Rights Act is a discussion on race, and so there has to be a consideration of race. It cannot be race predominance, that race is above all other factors when you are trying to create a redistricting plan, but the statute inherently and necessarily requires the consideration of race. So we collectively as advocates were unsure of whether the court would make perhaps maybe a part and parcel change to the standard, which would still require a lot of work on the part of organizations like the Lawyers Committee and other civil rights organizations for the cases that are currently in the court system. But had the court adopted the race-neutral benchmarks that were suggested by the state of Alabama, we would have a completely different framework and scheme for how we would bring Section 2 cases, which more than likely would result in less cases being brought to challenge redistricting plans and other methods of elections that we believe are violations of the Voting Rights Act.
Thank you. And then turning to Moore v. Harper, the second major voting rights case this term, what is the independent state legislature theory? I feel like I just started hearing buzzing around it in the last few years. Can you walk us through that case and kind of how that theory came about?
Absolutely. So the independent state legislature theory is based on the elections clause in the U.S. Constitution, which says that state legislatures are required to determine what the rules should be for federal elections in each state. So think, for example, just as was the case in Moore versus Harper, where you have a state that goes through the redistricting process to redraw its congressional redistricting plan. That is a process that has to go through the state legislature, which is what happened in North Carolina. Where the theory kind of unravels is that the state legislative defendants in North Carolina, their argument was that the elections clause of the United States Constitution gives state legislatures exclusive and independent authority to be able to set the rules for federal elections, essentially allowing them to go unchecked without any form of judicial review on the back end to really assess whether those election rules put in place actually are in accordance or in line with state law. And so what we saw in this case was that the Supreme Court relied on two particular kind of guideposts or benchmarks in saying that no, the Elections Clause does not give state legislatures complete authority to make election rules for federal elections, first based on history, which when the court does follow stare decisis and when it does follow precedent, a lot of times it will actually look to what happened during the founding of the United States, and after that to determine what are those processes? What does the history tell us about how we should view this issue? And what the court explains is that the history shows us that from the founding of this nation, states have been involved in judicial review of their own state legislative rules. Even prior to Marbury versus Madison, which is kind of the seminal case establishing judicial review, states were already doing this. The founders were actually having conversations about judicial review when they were drafting the Constitution. So this process of state judicial review for state legislative actions is not a new concept. And then secondly, the court also looked at its own case precedent, which goes back as far as 1916, and recently, as late as 2015, to establish that no, state legislatures do not have this kind of indefinite ability to be able to create rules around federal elections. And so that's very important because, again, like Aaron mentioned, many of the decisions that we have seen in the last couple of Supreme Court terms have not followed stare decisis. And what we have seen in Milligan and the Moore versus Harper cases is that the court is actually using its own case precedent and following that to really put some guardrails in place in the instance of the Moore versus Harper case, and also in the Milligan case, reestablishing the standard that is already in place for Section 2 cases.
Thank you. And this year was the 10-year anniversary of the Shelby County v. Holder decision, and though we've seen the court steadily chipping away at voting rights protection since then, this is the first term where we actually saw the court actually not do that. So I'm just curious, as a voting rights litigator, how are you navigating your work before the courts in this climate while the rule of law and stare decisis is in such flux?
Well, I think we have these decisions from the court, both positive and negative, and we do have to follow what the courts say as far as the law goes. And so as each decision comes down, reviewing those opinions with a fine-tooth comb to try to understand, what does that mean in a very practical sense for how we do our work. The reality is that the work can't stop. There's always an election, and so there's always the possibility that there may be a need for a legal challenge in advance of an election. And so it does require more strategic thinking about what kinds of cases, should they be in state court versus federal court? Are there other mechanisms potentially outside of the Voting Rights Act, perhaps if there are state statutes that do something similar, and we're seeing kind of this increasing wave of states that have enacted their own Voting Rights Act, so that may be something in the future that can be used when there's a need to challenge the processes or procedures of a state. But again, being very strategic about the kinds of cases that we're bringing, because ultimately we don't want to be in a position where we create more bad law. And so again, we have to be really thoughtful about what kinds of cases we bring, perhaps based on concurring opinions or dissenting opinions? What are the operative facts that are necessary to bring a case that can, withstand judicial review?
Thank you. And kind of taking a step back, and I know that we weren't able to touch upon like every single case that was decided, especially the 303 Creative case, which many of you may be familiar with, in which the Colorado business owner kind of, well, there's been some speculation about making up the case of it, saying that someone asked her to create a web design for a gay wedding, and then there's been some back and forth about that. But basically, the court said that she is allowed to discriminate against LGBTQ people. And I'm kind of thinking about the voting rights decisions, the education decisions, the environmental decisions, and just kind of how broadly across our rights. What do these decisions say about the current trajectory and the future of the Roberts Court? I know there's been a lot of discussion about the state of the Roberts Court as we've seen these rolling back of constitutional protections that many of us had when we were born, and now they're rolling back for the first time in our lives. So I'm just curious to hear your thoughts about that, for what you think they say about it. We can start with Bayless. Go switch up the order.
Yes. So what comes to mind for me first, I'm thinking about that Dobbs decision. I'm thinking about last year and how some of the cases came down. And it's my understanding that this year, in addition to like the Indian Child Welfare Act case, was a surprise as well. So I think that after the Dobbs decision leaked and everyone reviewed the cases that came out of that term, I think there was some concern maybe about the legitimacy of the court, and I think that this time around, to maybe quell some of those fears or maybe tamper them down a bit, there was, and I'm speaking from someone who was waiting on the student loan decision and the affirmative action decision. The other cases came out a little bit earlier, the Indian Child Welfare Act, the voting rights, and we're like, okay, well, these aren't looking too bad. And then like on a Thursday and Friday of June, the last ones, then you get the two big blows. So I think there are gonna be some moments of, I don't want to say trepidation, but maybe hesitancy but obviously this is not the time to take anything before the Supreme Court. And as I said, they did not outwardly overturn Grutter, but very much gutted it to the extent that you essentially did. So I think that we're going to see a lot of that, and I do hope that if we keep ringing the bell and sounding the alarm about legitimacy for the court, maybe they'll actually start to follow precedent. It seemed to work a bit from last year to this year, but yeah, this is not the time to bring cases before the court.
And I do want to say we are going to open it up for audience questions in a few minutes too. So if you have any, you can feel free to let my colleague Margie know, or you can speak up as well. Brielle?
I mean, I would have to agree. I think that despite these more positive decisions, legitimacy is still a substantial concern. I would say especially in the context of environmental law, not only with the last term in West Virginia v. EPA, but this term with Sackett v. EPA, where there were, it has to be stated, yes, that was a unanimous decision. However, the majority opinion and the other concurring opinions couldn't be any more different. I think it's absolutely wild that Kavanaugh wrote this concurring opinion that sounded like a dissent and was somewhat confusing, considering he doesn't have a track record of being a favor of regulation, let alone environmental regulation. But to me, that case paired with a few others is alarming in the context of that this court doesn't seem to care about science, doesn't care about scientific facts. Like, science is facts, it's not politics, right? So it's concerning that this court is unwilling to look at the facts before them and really take the time to review the administrative record to come to a reasonable conclusion, and is willing to really take fully on the complaints that were written wholeheartedly by polluting industry, and not like, alter them slightly, but it's almost like a copy paste of the complaints that were put before the court. So I think this court is one in which they don't seem to care about scientific facts, and that's going to lead to inconsistency. And inconsistency, to me, is a sign of illegitimacy. You should be able to somewhat have a good idea of where the court's going to go, and I don't feel that we have that right now.
I would also echo the comments of my panelists, co-panelists. Even in the context of voting rights, the Roberts Court does not have a great track record when it comes to voting rights cases. Of course, the biggest being the Shelby County versus Holder decision.
For folks who aren't familiar
Yes.
with what happened in Shelby County, because I know I also alluded to it too, can you share quickly what happened in Shelby County?
Sure. So the Shelby County versus Holder decision deals with sections 4B and 5 of the Voting Rights Act. Section 5 is the pre-clearance requirement, which essentially means that before any jurisdiction, particularly ones that are named or listed under this coverage map that's established in 4B, which is essentially based on a history of past discrimination in voting. Those jurisdictions are included in this coverage formula, and Section 5B says that, or Section 5 says that those jurisdictions have to get approval from the Department of Justice before they can make any changes to any kind of election procedure or rules. And so what the Supreme Court did, and Chief Justice Roberts wrote the opinion in the Shelby County decision, was to say that there isn't a need anymore for a coverage formula under Section 4B, kind of in a circular way, saying that, look at all the advances that we have made as a society. There is not a need for this coverage formula because jurisdictions are taking steps in the right direction not to discriminate against Black and other voters of color. And that is the reason why that this formula is no longer necessary. And what we have seen since then, because that decision effectively gutted Section 5 of the Voting Rights Act because now there's no formula for preclearance, what we saw was that states were waiting in the wings for that decision to come down. And when it did, voter ID policies were on the table and other kinds of measures that make it more difficult for Black and other voters of color to be able to participate in the electoral process.
Thank you. Are there any audience? Oh, sure. I'll start with you in the front.
Okay. Assuming that we have a Democratic Congress in 2025 majority, how many of these disappointing decisions could be changed effectively? And also, if there, if states made laws in agreement with these decisions, would the congressional law overtake that?
I can start. So tips for starting with the second question. Generally, Congress passes laws to be a baseline, so that way they're not preempting, what we would call preempting state laws that are more progressive or might be more friendly. So for example, with a lot of, in the paid leave context, even though we don't have federal paid leave, we have the federal, we have FMLA, but states like California and most recently Maine recently passed legislation, and Washington DC also has paid leave legislation as well. So the fact that we don't have paid leave at the federal level doesn't mean that states aren't allowed to still pass something. So whatever would be passed at the congressional level, assuming we had the votes to remedy these, wouldn't necessarily preempt any of the state laws that are in effect in the cases, generally.
I would say in the voting rights context, there are already bills that have been in process for the last couple of legislative terms, namely the John Lewis Voting Rights Advancement Act, which would really kind of resolve the Shelby County issue and hopefully also be able to firm up some other necessary protections for voters of color. So if there was to be a Democratic majority, perhaps that bill would be enacted, which, like I said, would, resolve some of the issues that came up from the Shelby County decision. With respect to state legislatures, like I said before, we're seeing a lot more states develop their own Voting Rights Act. I know Virginia has done so, New York, and most recently Connecticut. And so to the extent that other states are, primed and in position to enact their own voting rights acts, that's something that's very necessary because we don't know what Congress may decide as it relates to the John Lewis Voting Rights Advancement Act, and we have to make sure that there are at least some protections in place, particularly if, maybe that final iteration of the bill is not as strong as us as advocates would prefer to really shore up all the protections that are necessary.
Yeah, and I would, oh, sorry.
Go ahead.
I would just say it's similar in the context of wetlands specifically. I think that it is a fix that Congress could do, though I will note that they had already amended the Clean Water Act to make clear that wetlands should be protected whether they have a continuous surface connection or not. And that can just be seen throughout the 45 years since the statute was enacted, and all the previous administrations, including the Trump administration, that interpreted that statute to understand that wetlands could be protected even if there wasn't a continuous connection. So it's something that, yes, they could do, but they've already done, and so they'd have to be very intentional with that language. And I also think that, similar to some of what was just being explained about how, even if we do have control with the Democratic Congress, the ability for that to be weakened or hampered or tweaked with a little bit is still there. And climate is not gonna just stand still while we wait on Congress to shift and change. And that means that the individuals in the states that already have weak water protections, those state officials need to step into the breach and do things to enact laws to protect those communities. And the only thing I'll add to this, in addition to enacting these laws, there's an aspect of enforcing them. And that takes resources and money that states really do rely on the federal government to utilize. And that can't be any more true than it is for tribes and those on reservations that really rely on these federal protections and not state protections because of their own sovereignty that they have. So I think that it can't be understated that all of our elected officials need to be thinking about solutions to protect their constituents from the likely inevitability of climate disasters related to the devastation of wetlands and developers taking advantage of this decision.
Yeah, I'll just second what what they both said, but also noting that, even with the Democratic majority, I think it's going to require the voters to hold them accountable to actually passing the things, because we didn't have a majority in the Senate, of course, recently, but we were in a pretty good position, and it was sad to see the Crown Act pass the House and not the Senate, and it's that should have been an easy win, what just happened here, so, yeah.
Yes, sir, and then.
Yeah, I'm wondering what you all think about this kind of weird exception for military academies. What do you make of that?
Yeah, it's funny because I was listening to a session yesterday and I figured so I have my own personal thing.
Can you refer, so he's referring to the military exception that was in the SFFA cases?
Yeah, so it's saying that military academies could consider race and admissions. And I mean, for me, what it feels like is when you think about where, the military is set up to recruit, it's mostly in Black and brown communities. So why
Lower
not
income,
continue
too.
that? Yeah.
Yeah.
In Title I communities as well. I think that's part of the carve-out, the reason for the carve-out. And they likely could end up with a case around that one soon. as well.
Yes, you in the black shirt, and then we'll go to you in the back.
Yeah, I think it was to Brielle's point, just touching on that for a second. That's actually, you made the point that even if you pass a statute, that's not necessarily the magic goal. That's the same in Voting Rights Act, right? 'Cause it's been
Absolutely.
For many, many times, they still got it, or opposite. Anyway, my question is, I noticed that this court seems to offer or provide more sanctuary or deference to third parties bringing cases. Obviously, we saw that in the FA case, as well as to a certain extent in the 303 creative case.
Yep.
You mentioned, is there anything that from our side that we can maybe glean from that or think about, like maybe employing some of that strategy to kind of help us in a way if in fact the court is being more deferential to giving standing to third parties?
Yeah, I definitely did notice that finding standing where normally the court would say, where's the injury, where's the direct harm, and allowing cases to come before the court that normally wouldn't be heard. We could then say, can we have an advisory opinion? I mean, we could use that strategy, but given the conservative leanings for the court at the moment, I think that might put us in some hot water in some situations. But yeah, I mean, it's good to pay attention. I mean, this is all very strategic, as she mentioned. Once the voting rights, once Shelby versus Holder came down, bunch of laws in states ready to go. I mean, once the Dobbs decision happened, there were trigger laws just ready to go. So there's a strategy behind a lot of this that I think that we should be paying attention to and should be adopting some of those strategies. Well, let's take what works. But yeah.
I'll also add, it lifts up the importance, I'll be remiss if I didn't mention judicial nominations and the importance of it. Even though I know we're lifting up the Supreme Court cases here, the district courts and the appellate courts actually decide thousands more cases compared to the Supreme Court. So being engaged in judicial nominations at the state level and at the circuit court level are very important in terms of determining how the Supreme Court cases will even be interpreted and decided later as well. And then in the back.
Hi, yeah, my question is about standing as well, and there might be a little bit of overlap. So I think some people might argue that some of these cases didn't necessarily have a case of controversy, where the person raising the lawsuit wasn't even directly being harmed by the lawsuit that they were raising.
Yep.
So my question is, like, what do you think the court is going with standing? Have they thrown out standing all in all? Like, what is the status of that?
I don't envy constitutional law professors anymore for how they're navigating explaining Dobbs or just even the constitutional narrative. I finished law school like 10 years ago, and I just can't imagine how they're even trying to grapple with it, with still holding the court in any sort of reverence. But I will allow my panelists to take a stab at that.
What are you thinking?
I mean, you asked a really, really good question. I will say in the voting rights context, it's a bit more traditional where you have to have folks who have an injury in order to have standing. That being said, there are still some district court opinions, to Erin's point, about who is on the bench and the makeup of the bench. That we have seen in the redistricting context where there have been questions about organizational standing in redistricting and whether those organizations actually have an injury that they can bring that's separate than their associational standing on behalf of their members. So we are starting to see that in the voting rights context. And it will be interesting to see as the rest of the decade plays out and we see more redistricting cases over the next 7 years before the 2030 census, if that will continue to, kind of rear its head as an issue for plaintiffs to be very mindful of in determining, who would be proper plaintiffs to avoid that issue at the outset.
I'll also note for the medication abortion case, I think something that stood out to a lot of people was the fact that there was no standing to actually challenge it. Like in congressional statutes, they set out the parameters for when laws can be challenged, especially when they're setting guidance for agencies too. And in that instance, mifepristone, I think, had been on the market for nearly 30 years or so, and you have someone challenging it well beyond the period when the FDA's authority for approving it should have been considered through litigation. But that wasn't even something that was factored into, the lower court's decisions on it, as well as the Fifth Circuit when they ruled on it. And then you have the Supreme Court, they just issued a stay without having a formal opinion. But if the case does work its way back up to the Supreme Court, it would be a surprise to see, I guess, how they'll hash out standing there as well with ignoring congressional approval.
It's really tricky in the environmental context because standing has been something that has been utilized to keep environmental groups from the courts from being able to address their rights. And even when you look at a lot of legislative, like the rhetoric that's coming out of the Conservative Party, they are often attacking what's called citizen suits, which are provisions in a lot of our bedrock environmental laws that allow for individual citizens to bring claims against the government, compelling them to enforce the law that already exists. And so it's one of those things where sometimes when we see these arguments that are being made in favor of private are third parties that we don't, we are not bedfellows with, but the argument in and of itself would benefit, say, a different set of facts under an environmental case. That's very difficult, and I think similar to a lot of the traditional doctrines, they're not going to be predictable. And it seems like there's a different set of rules that are used for different sets of individuals. So I think that's something for sure for everyone to be tracking and watching, and also listening to what sort of rhetoric that the Conservative Party is using around litigation, especially governmental litigation, private party litigation. Yeah, I think we have to pay attention and use some of their language against them, which is what they continually do themselves. So, yeah.
Any other?
Just want to note on that note, as we are discussing a departure away from precedent for the court, I would consider standing to be one of those things at the moment. And I will say the importance of the state level and the district courts to kind of block out some of those cases before they even make it to the Supreme Court. There's a case that came up, I had to look it up to be sure, Speech First versus Shrum, and that was a lawsuit against Oklahoma State University from like a group that essentially said the anti-discrimination policies at this university are making it so that we cannot have free speech on campus. So I want to be able to say something very racist and if in this university setting, and I cannot say because the way the policy is set up, it harms. And so the district level court did kick the case for standing, but they brought it back again, initially saying, well, you didn't actually suffer any harm. You didn't, the university hasn't kicked you out. You haven't been suspended or expelled. You haven't said anything to get in trouble. So how are you testing this case? So a lot of that kind of stuff is popping up right now at the state level as well.
Any additional questions from the audience? Okay. I know we have 2 minutes left, but I want to hear from you all. I know that we've just kind of, where do we go from here? I feel like some of the questions from the audience were getting at that in terms of if we actually did have congressional power to enact changes. I know you all are involved in the policy and litigation landscape too, but what are the next steps for advocates for environmental justice, for educational opportunities, for racial justice and voting rights? And I'll start with Jennifer.
Sure. So I would just say, as I said before, the work has to continue. We all work on behalf of and alongside of communities that are harmed or negatively affected by these decisions and other decisions that come from the Supreme Court or lower courts. The need is still there. And so even when we have these kinds of court terms that, for the most part, are not positive for the issues that matter to us, somehow we still have to dig deep, take the wins where we can, and, kind of use that to fuel us going forward, because there will still be, people who, might get pushed out of a district because of their race. There, may be all kinds of scenarios, and so we have to continue as advocates, whether it's in the courts or outside of the courts, and I would really emphasize outside of the courts, because to a certain extent, there's only so much that can happen in court, but organizing work that happens outside of that is very critically important. So we really have to kind of galvanize around what is important, but also remember that there are some other avenues outside of the court system to keep the work moving forward.
Bayless?
Yeah, I would say that it's important to remember, particularly in the education context, that there's still room to do the work that we want to do, and let's always make sure that we're doing a very close reading of whatever comes down, and don't give them any more than it is that they want to take at this moment. And so there are still ways that we can ensure that universities have a diverse student body, and make sure that I think this is the time to lift up the universities that have been doing really great work at maintaining a diverse student body and matriculating a class of diverse students. So I think there is still room to do the work that we want to do. We just have to be more strategic about it, and there are people who are already doing amazing work, and so we just have to follow their path, and don't bring any test cases before the court right now, please.
Priya?
I would say definitely we need to stay engaged, stay informed, educate ourselves about what's at stake to the immediate environment that you're experiencing on a day-to-day basis, as well as at the federal level. I feel that oftentimes where there are wins or gains, there's when people don't actually understand what rights, what environmental protections are being brokered away from them. And so I think people really understand, like, oh, there's the Clean Water Act and it's important, but they don't necessarily comprehend how that impacts them on a day-to-day basis. So I think people really need to stay engaged, stay informed, and pay attention to what our elected officials are doing and hold them accountable where we are capable. Use our voting voice, right, to hold them accountable. And then the last thing that I would say is to remember the history that has happened before we got to this point, not only to help us be informed, but to help motivate us. I think about the fact that people before me had less at their disposal as tools to get themselves places than I currently do, and that I think is empowering.
Thank you. I'll also add to that in terms of the engagement and for educating is to, if you're not already, definitely check out all of our organizations, because we have immense wealth of resources that are helpful for you to engage and get additional background on any of the cases we talked about today. There's also different calls to action that we have surrounding the different bodies of work as well, for petitions for engagement that can be sent to elected officials as well. So, but thank you all for joining us today. I definitely appreciate it. And I hope you enjoy the rest of your time at Netroots.